Hello, everyone, and welcome to One Civil Law. And my friends, the rebellion in the federal judiciary continues as a second judge has now taken the step to refuse to dismiss with prejudice, instead converting it into a motion to dismiss without prejudice on their own initiative, sua sponte. So earlier today, I covered a judge who whined and kvetched all over the page about how mad they were that they had to do the thing. And they whined and they bitched and they said they didn't want to, but then they did it anyway. But then a second judge, Judge Beryl Howell, has decided not to dismiss with prejudice. So they are refusing to accept the motion from the U.S. government to dismiss with prejudice. So we're going to go ahead and read this. This is a thing that's happening. We turn our attention to the case of United States of America versus Nicholas DiCarlo and Nicholas Oakes in the United States District Court for the District of Columbia, wherein the following has occurred. The United States government moves to dismiss with prejudice, which is to say, literally prejudge. That's what prejudice is, right? Prejudice is literally to prejudge. It's like literally, no matter what you say, we know what the answer is, because it prejudges any future case. And so they're like, we'd like to dismiss with prejudgment as to any further case we bring. No matter what we bring, we already know the answer. So they move to dismiss with prejudice, which effectively means the case can't be brought, the 9-count superseding indictment against defendant Nicholas DiCarlo and Nicholas Oakes. These two defendants, by their own admission, engaged in criminal assault against law enforcement officers by throwing smoke bombs at officers, as well as property damage and theft. The statement of offense of Nicholas Oakes provide a factual basis for defendant's guilty plea due to their belief in the falsehood disseminated by political leaders and others that the 2020 presidential election was stolen, when no evidence of any outcome determinative election fraud has ever been uncovered, let alone confirmed by any federal, state, or local government agency or court of law. Sounds suspiciously like a political statement, but okay. Nevertheless, for reasons explained below, the government's motion is granted in part and denied in part, and the pending indictment is dismissed without prejudice. Dismissed without prejudice, which means hypothetically, the U.S. government could bring the charges again, presumably like at any time they wanted to. So they could bring the charges again. So the prosecution of the January 6ers may continue. We'll see. Some people are not getting the memo. Let's read more about the court's exciting reasoning for this. The two defendants in this case, one of whom found the Hawaii chapter of the Proud Boys and served as a senior group leader, both admitted under oath, with advice of counsel and pursuant to a plea agreement, they voluntarily entered with the government. Their criminal conduct to the U.S. government on January 6, 2021. Both men admitted to throwing smoke bombs at law enforcement while on the grounds of the Capitol. Both men admitted to breaching the Capitol building, using the Capitol building to meet up with other members of the Proud Boys while inside the building, defacing the Capitol building, and stealing equipment from law enforcement officers responding to protecting the building and its lawful occupants from the rioters. There is a bit of an artifact on the screen, you're right. Fixed it. Great. Moving on. Let's see. Where were we? Okay. After the defendants both pled guilty to one count of obstruction of an official proceeding in violation of law, the remaining 5 charges against each defendant were dismissed. Defendant each reported to prison, and in accordance with waivers in their plea agreement, neither filed a direct appeal. In the wake of the Supreme Court's decision in Fisher, which limited the applicability of federal felony obstruction statute to the January 6 conduct and was issued 18 months after the defendant's sentencing, this court vacated defendants' felony convictions, granting their motion pursuant to law. Roughly 2 months later, on January the 15th of 2025, the government filed the pending second superseding indictment, charging the defense with 9 federal counts, including 7 felonies. Conspiracy to prevent an officer from discharging duties, assaulting, resisting, or impeding officers with intent to commit a felony, assaulting, resisting, or impeding officers using deadly and dangerous weapons, civil disorder and aiding and abetting, destruction of government property, theft of government property in violation of law, restricted buildings or ground with a dangerous or deadly weapon, disorderly or disruptive conduct in a restricted building or grounds with a deadly weapon, act of physical violence in a restricted building with deadly weapon in violation of law. In sum, the current posture of the case is, even after the defense admission of egregious criminal conduct, both outside and inside the U.S. Capitol building on January 6, 2021, and the government expending significant time and resource in identifying defendants, investigating their criminal conduct, filing 3 separate indictments against the defendant, negotiating and executing a plea deal with the defendant, and vigorously contesting their Section 2255 motion at every step, the government now seeks to dismiss the pending second superseding indictment against the defendant under Federal Rule Criminal Procedure 48A. Yeah, I mean, we have a new boss in town. I'm not sure if you noticed. I'm not sure if the judge noticed, like, that there's a new boss in town. We have a new chief executive. I know. Apparently the court is surprised, right? The court is surprised. We have a new chief executive, and the new chief executive doesn't want to keep doing this anymore. And also, the judge isn't supposed to care personally. The judge seems to be taking this very personally. Like, the judge isn't supposed to care, like, who wins and who loses. But the judge seems really, really salty that, you know, the government has worked really, really hard. And then they're like, we don't want to do this anymore. The government isn't allowed to change their mind and not prosecute people, don't you know? Courts have limited power when the federal government decides to stop prosecuting a criminal defendant. They sure do. At the same time, the Supreme Court and D.C. circuits have both recognized that a leave of court requirement in 48A obviously vests some discretion in the court. Knowing the rule gives the courts a role in dismissals following the indictment. And this is like the key part typically, right? This discretion to the court is granted in part to guard against abuse of prosecutorial discretion in a way that would prejudice the defendant, incidentally. In a way that would prejudice the defendant. So the reason the court has this review is to prevent the prosecution from dismissing in a way that would harm the defendant. And in other words, they're dismissing for strategic reasons with an eye towards future prosecution, or an eye towards just bringing the charges. You know, bringing the charges, dropping the charges, bringing the charges, dropping the charges, bringing the charges, dropping the charges, right? This kind of ping pong thing, for example. So they're not dismissing out of good faith. They're doing it in a way that would prejudice the defendant. So the court can basically be like, no, you can't do that because it violates due process, basically. You can't just dismiss if it's going to abuse the defendant, because the defendant is entitled to both procedural and substantive due process. So that's the reason the rule exists. But that's not the reason the court is going to use it right now. To ensure the government's request for dismissal of criminal charges sufficiently protects the public, the government may be required to submit a statement of reasons and underlying factual basis, which must be substantial to justify dismissal and not a mere conclusory statement. Only if there's reason to think that they're doing it to prejudice the defendant, which is a little bit hard when it's a motion to dismiss with prejudice. You know, you never, as a lawyer, want to say something's impossible when it's the first time you've ever thought about it, right? It's like, okay, is it possible to dismiss with prejudice? Which, incidentally, the prejudice is against the government. So is it possible to dismiss with prejudice to the government in a way that would harm the defendant? I'm struggling to think of how that would occur off the top of my head, but you never want to say never. But it sounds pretty difficult. How do you dismiss with prejudice to the government in a way that also prejudices the defendant? The defendant really has a very strong interest in being prosecuted. I don't know, man. I don't know. That seems rough. Here, the government's cursory motion provides no factual basis for dismissal. Well, other than the chief executive saying we're not going to do it anymore. Instead, the single paragraph explanation included in the one-page dismissal cites as a reason for dismissal only the presidential proclamation dated January 20th, 2025. Yet only the president said to stop it. This cited proclamation, among other things, directs the Attorney General to pursue the dismissal with prejudice to the government of all pending indictments against individuals for their conduct relating to events at or near the U.S. Capitol on January 6. The only reason provided for this instruction, as set out in the President's introduction, is the assertion that the action ends a grave national injustice that's been perpetrated upon the American people over the last 4 years and begins a process of national reconciliation. No national injustice occurred here. You're contradicting a political determination, but judges don't do politics; they do law. Judges don't do politics. If it were the legislature saying this, then I guess maybe, but you're not supposed to make political statements. You're supposed to make legal statements. So you're contradicting a political statement. Okay. No process of national reconciliation can begin when poor losers whose preferred candidate loses an election. Holy shit, we're a little hostile. He just called the people who voted for Trump losers. That's exciting. Are glorified for disrupting a constitutionally mandated proceeding in Congress and doing so with impunity. That merely raises the dangerous specter of future lawless conduct by other poor losers and undermines the rule of law. Well, one of those rules is that the executive gets to choose who to prosecute, and they can stop prosecuting in a way that doesn't undermine the defendant's rights. So that's also one of the rules. Yet the presidential pronouncement of a national injustice is the sole justification provided for the government's motion. I'm not sure the president requires a reason to stop prosecuting people. This is a really interesting prospect, right? Does the president need a reason to stop prosecuting you? Now, if they have nefarious reasons to stop prosecuting you, then we're back to what we were discussing earlier, right? That was what this carve out in Rule 48A was built for, right? This reason for the judicial review. So if they have nefarious reasons to dismiss, then those nefarious reasons might arrive at a violation of due process, either procedural or substantive, right? If they're doing it out of a Machiavellian plan to fuck you over, then fine. So if they have nefarious reasons, fine. But if they have no reasons other than their whim, it's a whim in favor of the defendant. It's a whim in favor of the defendant, right? If the prosecutor were prosecuting you on a whim, then again, maybe a due process violation, selective prosecution, that kind of idea. It's a selective prosecution. It's retaliatory prosecution. It's a violation of due process. So if they were deciding to prosecute you on a whim, maybe. But the decision not to prosecute you on a whim, that's, kind of not the same thing. So I'm not sure they need a reason, although the judge seems to think they do for some reason. Having presided over scores of criminal cases charging defendants for their criminal conduct, you got paid, though. You got paid. That was your job. You're a federal judge and you got paid in everything. So, and you're not supposed to care who wins or loses. And you're particularly not supposed to care when none of the rights of the defendant are being violated. But you care for some reason. Having presided over scores of criminal cases charging defendants for their criminal conduct, both outside and inside the U.S. Capitol building on January 6th, which charges were fully supported by the evidence in form of extensive videotapes and photographs, admissions by defendants in the course of plea hearings and testimonies at trial, and testimonies of law enforcement officers and congressional staff present at the Capitol that day, this court cannot let stand the revisionist myth relayed in the presidential pronouncements. What the hell? What the hell? This is so political. This is kind of unbecoming of a judge, man. This is, yeah. The prosecutions in this case and other charging defendants for their criminal conduct at the U.S. Capitol on January 6, 2021 presents no injustice. Again, disagreeing with the president's political judgment, which is very weird, but instead reflects the diligent work of conscientious public servants, including prosecutors and law enforcement officers, and dedicated defense attorneys to defend our democracy and rights and preserve our long tradition of peaceful transfers of power, which until January 6, 2021 served as a model to the world, all while affording those charged every protection guaranteed by our Constitution and the criminal justice system. As these two defendants specifically both admitted their criminal conduct under oath after consultation with their attorneys and pursuant to a plea agreement in which they reached, bluntly put, the assertion offered in the presidential pronouncement for the pending motion to dismiss is flat out wrong. The government can't stop prosecuting you. The government has to prosecute you. This puts prosecutorial discretion in a whole nother exciting light. This puts prosecutorial discretion in a whole nother exciting light. They have to keep prosecuting you. Okay. Even though they don't want to. This is an interesting aspect of law. Didn't they do this to General Flynn? They did something. It's been a while since I forgot how they fucked General Flynn. But you're not wrong for asking the question. It's been a while since I forgot exactly how the judge in that case was bending over backwards to continue allowing the prosecution of Flynn. It's been a hot minute, but your question isn't invalid. I forget exactly what they did to Flynn, but something like that, yeah. This is exactly what they did to Flynn. I just can't remember well enough. It's been a while. Despite finding the sole reason relied upon by the government to dismiss the charges in this case, an incorrect assertion in the presidential proclamation, it is neither substantial nor factually correct. The government's view of the public interest does not clearly fall within the types of reasons found to be legitimate grounds to deny the motion to dismiss charges. Yeah, how could it possibly be when the public interest is the same as the defendant's interest? And then they give examples in U.S. versus Flynn, ironically enough, where they collect examples where the government's motion to dismiss should be denied as not serving a legitimate interest because the motion was a sham or deception. In other words, they're trying to fuck with you. Was based upon acceptance of a bribe, they're corrupt, personal dislike of the victim. You know, that's selective prosecution. They're not supposed to prosecute because they don't like you personally. And dissatisfaction with the jury impaneled, or was meant to favor politically well-connected individuals. Therefore, the government's motion to dismiss the indictment is granted. Nothing about the government's reasoning for dismissal warrants entry of dismissal with prejudice, however. Dismissal with prejudice is complete adjudication of the matter and would bar any further prosecution of defendants for the offense conduct at issue. A dismissal with prejudice is a final judgment on the merits. It prejudges. It literally prejudges. That's what prejudice is. Literally judgment in advance. A dismissal with prejudice is a final judgment on the merits, which bars further litigation between the same parties. The dismissal with prejudice of criminal charges is a remedy rarely seen in criminal law, even for constitutional law violations. I mean, okay. This result would be improper here, particularly with defendants' own admission of criminal conduct, including throwing smoke bombs at law enforcement officers who were trying to valiantly prevent rioters from entering the Capitol building, provides ample basis for criminal prosecution. Instead, the government's reliance on policy assertion made in the presidential proclamation that such prosecution should not be continued warrants only rendering the proceedings a nullity and leaving the parties as if the action had never been brought, which is achieved by granting the government's motion to dismiss with prejudice. Unbelievable. Unbelievable. Wouldn't the same argument nix all of Biden's pardons? Well, no, not exactly. This is, yeah, we can spend a moment on this point. No. So Trump's actions did two things. Well, I guess they did three things technically. Trump's memorandum did three things. It pardoned some people. It commuted the sentence of some other people, and it ordered the government to dismiss with prejudice for yet other people. And a dismissal with prejudice is not the same thing as a pardon. It's not the same thing as a pardon. So it doesn't impact pardons. No. But it's still freaking dumb. For reasons above, the government's motion to dismiss is granted to the extent that the second superseding indictment against defendant is dismissed, but denied is the request that the order be dismissed with prejudice. Hereby order that the second superseding indictment against the defendant is dismissed without prejudice. The status conference is vacated, and the clerk is ordered to direct the case. Signed, Beryl A. Howe. Well, that's super exciting. Beryl A. Howe. Let's learn a little bit more about Beryl Howe. She's a senior judge. Who was she appointed by? Barack Obama. No. Yes. Yeah, she was appointed by Barack Obama. Beryl Howe, born December 3rd, 1956, is a senior United States District Judge. So she's no longer active. She's senior. She has retired. But she's still hearing cases. As chief judge, she supervised federal grand juries in the district, including for the Mueller special counsel into Russian interference and investigations into attempt to overturn the 2020 presidential election. Exciting. So, yeah, I guess that's not particularly surprising. What else did she used to do in her history? She was a lobbyist for the Recording Industry Association of America and Universal Music Group, UMG. That's interesting. Well, yeah. In 2018, she struck down a regulation that allowed dark money and allowed people to conceal their donors. She became the supervising judge for the grand jury working for the special counsel for Robert Mueller. She ruled in favor of the House Judiciary Committee, which sought grand jury materials from Mueller, finding the impeachment inquiry into President Donald Trump to be a judicial proceeding, which is one hell of a conclusion. She found the impeachment inquiry by the House to be a judicial proceeding. How? How do you determine that the impeachment proceeding is judicial? That's what? So she has some interesting view. Yeah, no, it's a legislative proceeding and it's political, not legal. I've commented on this multiple times. Like, it's political, not legal. But she said it's judicial, even though it's being done by the legislative branch, which I guess hypothetically, right, depending on your point of view, you could view the pardon power as a judicial power. I mean, you're getting into like classification territory at that point. Like, do you view the pardon power as a judicial power, even though it's done by the president? I mean, you could view it as a judicial power, even though it's done by the president, but it's a little bit hard. I don't know how you view impeachment as a judicial proceeding. I'm not sure how you do that. That's an interesting one. I'm not sure how you do that one. Yeah. In what sense is it judicial? Do I have to read her decision now? I might have to read her decision and try to figure out how she said the impeachment is a judicial proceeding. Impeachment inquiry is a legal proceeding, the judge rules. How? How do you get there? I mean, they do call it a court of impeachment, but still no. You know, court, I mean, the concept of a court doesn't necessarily have to be judicial either, because one of the, you could have the concept of court being an executive idea. You wouldn't use this language today, but, very much, but you would talk about the innermost circle of the king being the king's court, for example. So the idea of like a court being an executive branch function or even a legislative function, I was like, I guess, but I'm not sure how that makes it legal as opposed to political. Yeah. Yeah, that's an odd thing. The Chief Justice presides. Yeah, that doesn't make it that doesn't necessarily make it a legal proceeding either. But that would imply that that would imply that impeachment of the vice president is arguably is different than impeachment of the president, as in terms of whether one's legal or not. Yeah, I don't know, man. Can the DOJ appeal without prejudice? Yeah, I guess you could. And so could the defendants, for that matter. I suppose they both could appeal. So maybe they'll appeal to the Court of Appeals for the DC Circuit. I guess you could appeal. Yeah. Yeah. How does a judge get to ridiculous conclusions? They fart and explain to everyone how it smells like perfume. I guess. I don't know, man. Well, in any event, my good friend, potentially criminal, is going to be going over some of this stuff. So I'm going to send you his way as soon as I find the thing to send you over there, because his stream should be starting right now too. And he's going to be going over some of these decisions by some of these judges. I'm not sure if he's going over this decision or not, because I talked to him a half hour ago and he didn't know this decision existed. But maybe he's been watching this and maybe he now knows it exists. So maybe he'll talk about it now too. Hold on. Can I not send over to people to potentially criminal? I'm not sure I can send people over his way. Yeah, I mean, it doesn't exactly speak well of chief judges, because she was chief judge. You know who else was chief judge? Because she was chief judge of the DC Court of Appeals. Yeah, she was the district's chief judge. It doesn't exactly speak well for chief judges. Yeah, who was the chief judge of the Court of Appeals of the DC Circuit? So it doesn't necessarily speak very well of the reputations of chief judges. By the way, for those of you not picking up what I'm laying down, the answer I was looking for was Merrick Garland. So, Merrick Garland was chief judge of the DC Circuit. So it doesn't necessarily speak well for chief judges. All right, I'm going to send you over to potentially criminal. He's going to be doing some stuff today. It should be fun. Thank you for the 800 of you who are here. Do a few super chats, because there were a couple, actually. $1.99 from the Chugi Show Live, who said this judge should be removed. Peter Watkins, who said for $4.99, he says, if I was the defendant, I kind of not care. Oh, we rebrought pardons. Me, interesting. Here's my presidential pardon. Except this person doesn't have a pardon. At least not yet. This person doesn't have a pardon. So they care a little bit more. Professor Chaos for $5 said, couldn't this be used by a good attorney to get the judge recused from cases for clear bias? I suppose, but then of course the judge themselves is the one that's sitting in those judgments about whether or not they're biased or not. So it's really problematic. So yeah. All right, I'm going to send you over to Sean. Be nice. His chat is degenerate. Don't become degenerate like this chat. Be better than that. I'm going to send you over that way. I've been on Civil Law. Till later, my friends. I hope all is well. Cheers for now, my friends, and goodbye. Although we're not completely done because, as I sort of said in my other streams, there will be other cases from other judges. Oh yes, we're not done. We're only done for now. There will be more. There will be several more. I have very little doubt. Yeah.